love you, I feel good, you look great, I like you, I can't wait. A first time, a first date, you're so fine.
Okay, so welcome back to the channel at Rideshare Buddy UK. I'm not planning on doing a video every day, but just to launch a channel, I'm trying to get a few of the interesting news stories out there, something that Rideshare and private hire drivers really should be aware of. I've covered the proposed changes in Welsh regulation, and today I'm looking at that infamous Uber versus Sefton Borough Council case, which is still under consideration. Now, this was an application by Uber to the High Court for a confirmation of the definition of what a private hire car is and what a private hire operator is, and the basis of the contract between the customer and the private hire operator. This only applies to local authorities outside of London, so in main England and in Wales, until new Welsh laws comes into effect. It doesn't cover London because London is covered by separate legislation, but outside of London it's covered by the Local Government Miscellaneous Act 1976, so about just under 50 years of existence. And why this case has happened is because Uber has been came to a settlement with the VAT man last year and paid £615 million in back VAT. Now, they were required to pay VAT because the courts decided that the contract on the Uber app is between the rider and Uber. It's not between the rider and the driver. And that's the way it's always been under private hire. It's always generally been accepted that contracts are between riders and drivers, and the private hire operator is effectively an agent. Or that's what it's been sort of viewed as, really. But it's not what the Act says, and we'll come directly into that. So what Uber has done, because they now have to pay VAT on all their fares, is saying, well, actually, it's not really fair that it's just us who has to charge VAT. Every private hire operator should also be in the same position that they're in. And that seems fair enough. They're basically operating the same. The problem at the moment is with Uber is because they have to charge the app user VAT rather than adding on to the fare, which will make them really uncompetitive. They're not the cheapest anyway. But if they have to add an extra 20% onto the rider, then they could destroy their customer base. So rather than pass it on to the customer, and rather than withstanding it in their own profits, what they've done is they've passed that on to the driver. So the cost of that 20% VAT has come off what they pay to the drivers. And that's why basically Uber is now the lowest paying rideshare app or private hire app or private hire operator in the country now. It's quite a long way behind everybody else because they've taken that 20% VAT off the driver to pay to the Batman. So what Uber wants is for all private hire operators to pay VAT, and that would hopefully mean that instead of the driver, that cost being passed on to the driver, all of the industry will have to raise the prices up by 20%, and then the drivers can carry on getting their fair share of any fares. So that's what the case is about. It went into the courts in November last year. There was a 2-day hearing. It was expected that a decision would have been made by now. They were expecting a decision on the definition of that contract to be made in December last year. It still hasn't come through. And on the case board website, the case is still active. And the last activity was on the 3rd of May of this year. So now we're at the end of May. I think a decision is going to come through fairly soon, in the next few weeks. that further mate, it didn't say what that case activity was. It might have been a judge taking advice from somewhere. But we'll have a closer look at this. But that's the basis of what this is, and the implications of how the judge rules on this is quite far-reaching. It's not just a definition. There's a lot associated with what will happen on that decision. So let's actually look at what the one sentence in the Local Government Miscellaneous Act 1976 is all about and what is causing the issue. Right, so the actual sentence of the case, which the judge has been asked to rule on, is Section 56(1) of the 1976 Local Government Miscellaneous Act, and this is how it reads. For the purposes of this part of the Act, every contract for the hire of a private hire vehicle licensed under this part of the Act shall be deemed to be made with the operator who accepted the booking for that vehicle, whether or not he himself provided the vehicle. So basically, that one sentence says that the contract is between the rider and the private hire operator. And in that case, because the private hire operator then is not an agent but a principal, he owns, i.e. they own the contract, that they have to pay VAT on that. And that's quite important because up to now, with it all being down to the driver, because not many drivers are doing £86,000 a year, which is the VAT threshold, VAT isn't payable. But if you put together all of the bookings within a private hire operator business, then they're going to be over that limit and they'll have to pay VAT to the VAT man. Now, for some reason, for the last 50 years, the VAT man hasn't really pursued this until Uber came along. And then, of course, they saw big money. I mean, there were reports of Uber having to pay up to £1.5 billion in back VAT. But they came to an arrangement with VAT man for £615 million instead. So that was big money, which was a motivator for the VAT man to start looking at this contract. And it seems to me as though all private hire operators really should be paying VAT, because that sentence says that the contract is between the person who books the car and the operator. But is that what's being explained in court? That's Uber's argument. But does Sefton Borough Council accept that argument? Let's have a look.
No. Enter an army of lawyers from Sefton, Visu, Delta to try and muddy the waters. They're saying no, that this is not what it appears to be at all. So we've made the argument that this is, similar to Uber, but for different reasons. That this is exactly, it means what it says on the tin, nothing else. But Visu and Delta were kind of saying, well, first of all, they're saying that what it means is the regulated bit is just the invitation, what is the language? The provision for the invitation and acceptance of bookings. And so what they've tried to do is split it in the middle and say the regulated bit is the invitation for the acceptance of bookings, while the accepting of the booking is not regulated at all, and therefore drivers can do it. And amazingly, Sefton made the argument in court that no, anybody can accept a booking. So drivers could accept a booking. Now that'll come as a big shock to anybody who was ever prosecuted for plying for hire in Sefton, because Sefton Council is now saying it's no offence there at all, anybody can accept a booking. And this is just turns on its head what everybody thought was the right thing for years. But that's the mental gymnastics they have to go through to try and make 1976, that section that I've just read to you, mean something other than what it means. Because what they're saying is the problem is around the word deemed. It is deemed to be a contract. And what they're trying to say is all that means is that for the purposes of regulation, there's deemed to be a contract. It doesn't mean there really is a contract. It just means to say there's regulation for this piece. Doesn't make any sense. I know I'm boring myself talking to you, but this is the kind of nonsense I've been listening to for 2 days. And it's particularly disturbing to hear Sefton, Visu and Delta make those types of arguments, because it's so contrary to what everybody has lived with for many years. Because they don't want this Section 56 to mean there's a contract. The second argument they would make is that just because it's deemed for the purposes of transport regulation doesn't mean there's actually a private contract there. You couldn't run off to the county court and make a claim against an operator who hadn't breached their contract with you for transport. The judge asked, well, why not? Why couldn't you do that? Why couldn't you do that? And really all the Parliament were trying to do at the time is just to make sure that if an operator accepted a booking, they couldn't subcontract it out to 1,000 people and it's lost and then nobody's responsible for it anymore. What Parliament was trying to say is you accept that booking, you own it. You accept that booking, that passenger has come back with you. Now you can pass that to whoever you want to, it's on you. You're responsible. You accepted the booking, you're responsible. That makes perfect sense. What these guys are trying to say, oh no, but there was a difference, get this, there's a difference between, I want to get this right, accepting a booking of a vehicle versus accepting a booking for the hire of a vehicle, right? So for one is, I tell you what are you doing? You're reserving a vehicle, and the second one you're actually hiring the vehicle. That's where we were at today. This is like crazy town.
That video was taken from the ADCU Facebook page, the App Drivers and Couriers Union, and it was by James Ferrer, who was at the hearing, as you heard, and that was part of a 25-minute video. You can find it on the Facebook page, look at the videos, well worth watching the entire video as to what sort of things was going on in the course over that case. But what's really interesting is how Sefton says that drivers are allowed to take the actual booking. The only part of the booking, the act of the booking, that is regulated is the invitation to book. So me, you, as a private hire driver, if we sat in the side of the road, according to Sefton, if we stuck our head out of the window and shouted, anybody want a taxi? We'd be inviting a booking, and that's regulated and would be breaking the law. If we sat in our taxi, minding our own business, and somebody comes up to the window, knocks on the door on the window and say, can you take me to XYZ? And according to Sefton, yes you can, because that part is not regulated and you're free to do that. Now just think about that. That means for the last 50 years, all those sting operations run by local council or enforcement officers, catching private hire drivers out, knocking on the window saying, can you take me to XYZ? And then fining them, revoking the licence, suspending them for plying for hire, all those operations would be unlawful. 50 years worth of operations would be unlawful because it would be a misinterpretation of that sentence, that law, if the judge rules in favour of Sefton. I can't see that happening. Two things are going to happen when this review comes through. Either one, the private hire operators are going to have deep pockets and pay out a lot of backdated VAT, how much will be determined by the VAT man. Or two, the judge will rule in favour of Sefton, in which case all of those no win, no fee lawyers will be lining up to take local councils to court for recovery of lost earnings, compensation, and all sorts of stuff for drivers who have been impacted by those sting operations, because those sting operations would be unlawful. So either the private hire operators are going to be paying out big bucks, or the local councils are going to be paying out big bucks. And I think this is one of the reasons why the judge is taking so much longer than expected to rule on this case. If she comes down on the side of Sefton, then, well, number one, Uber will want their VAT money back from the VAT man, because the judge would have ruled that it's the driver's responsibility, not Uber's. That's number one. But number two is that it will impact and make 50 years of convictions unlawful because no law was broken. So I don't think she's going to go down that route. I think the obvious way is that Uber will win this. It has to win this. The impact of not going down what the Act says, because the Act says that the operator is the principal. If she goes down the route of Sefton, she's overruling the Act. She's putting a lot of councils at risk of prosecution. She's going to be overruling a lot of convictions, 50 years worth of convictions. And it goes against the operating procedures of 50 years of work. So I don't see that happening. I think she's going to go down with Uber. I think there's going to be a lot of local taxi companies around who are going to have to find a lot of money to pay off the VAT man. And really, hopefully, what that means is because everybody then goes onto the same level playing field, they all have to charge VAT. Then hopefully the fares, well, not great for customers, but the fares will go up 20%. And that means the drivers won't lose out. What the worst possible outcome of this would be that she finds in favour of Uber, and all the local authorities, all the local taxi companies just cut the pay of the drivers. That could be the worst outcome. It has to be a case of VAT being added on to the fare, which is, I think, probably the fairest way of doing it. But I think we'll still wait on this. Hopefully, in the next few weeks, we're going to get a result. But it's going to be interesting. If the judge rules in favour of Sefton, and that the contract is between the rider and the driver, is she going to be able to find a get-out clause to protect the councils and to protect 50 years worth of convictions from sting operations? This could be why it's taking so long. But until next time, that's it. Sefton or Uber versus Sefton still hasn't come through yet. I'm fairly sure it's going to come through in the next couple of weeks, but we'll wait to see. Yeah, an interesting case.